request, but I don't think it would enhance his punishment because I think it has to be a prior felony conviction before the date of this offense. Help me out. Am I right? I'm looking at all the lawyers. Everybody?
I think you are, Judge. Yeah.
Okay, so forget everything we just.
Judge, on Mr.
All right, so hold on. You're Davius Williams, and this is 25 DCCR 0176. Mr. Williams is charged with injury to a child, elderly, or disabled individual, and what is the announcement?
Your Honor, Mr. Williams, and I filed the motion in this case after I explained and sent Mr. Williams a communication explaining what he was subject to in terms of punishment and what the state has indicated their enhanced punishment range and a motion to accumulate coming on a jury trial. He immediately told me he did not want me to represent him because I don't show his best interest. He would like to fire me. So
you're court appointed, right?
Yes, Your Honor.
You don't get to fire your court appointed lawyer. You can fire someone you hire. Mr. Wilkerson is an excellent attorney. He handles many cases for all of us here in Jefferson County. If he's advising you of whatever your situation is, then your situation is what it is. So we can go through and what you're charged with and make sure we're all on the same. I feel like we've done that before because we've already had a plea bargain rejection, but let's do it again. It looks like you're charged, it's a third-degree felony, which means the punishment range is between 2 years and up to 10 years. However, it looks like, has there been, I don't see a notice filed of extraneous, but are there some that you anticipate filing?
yes, Your Honor.
Mr. Smith?
Yes, Judge.
Two prior statements.
There's a third degree. Excuse me, Judge.
Hold on just a second while they get this figured out, and then I'll let you ask any questions you have, okay?
No, come with me.
So, Judge, there's a state jail for criminally negligent homicide. There's another state jail for attempting to take a weapon. And then there's the third degree that Mr. Smith mentioned. There are no other TDCJ convictions.
So the third-degree felony conviction, if true, would enhance your punishment in this case, if you were found guilty, to the second-degree range of punishment, which is between 2 years and up to 20 years. Do you understand that? Okay. And it looks like we previously did a plea bargain rejection, and at that time, the third-degree felony was checked off instead of the second-degree admonishment. But I do want to make sure you understand today that if you go to trial, and if that conviction for the third-degree felony, the state jails don't enhance you, but the third degree would to a second-degree felony range of punishment. It looks like that rejection was for a 4-year term in prison. Is that still the offer?
That was the offer as of this morning.
Okay, so the offer is for 4 years in prison. You already said that you didn't want that. If you want to change your mind after discussing your options with Mr. Wilkerson, then we can take care of that. If you don't, then we'll set your case for trial. Mr. Wilkerson will prepare for trial, and we'll get it taken care of as quickly as possible. Yes, sir.
There was one more thing. The state had indicated an intent to file a motion to accumulate he just had an 8-year sentence on an MTRP.
If you recall, Judge, we had a contested motion to revoke probation with this as the allegation. We proved that up. You gave him an 8-year sentence.
Okay.
So that 4-year sentence that we had offered today was to run concurrently with that.
Okay,
If he rejects that, then we will file a motion to stack whatever he receives from the jury in this case on that 8 years that he's already served.
so I want you to understand, so the third degree conviction, is that something other than the conviction? The revocation, or that's the one that,
The revocation was for a injury to a, no, that was,
the prior conviction that y'all are talking about, that third degree,
That's on the MTRP,
that's on the MTRP?
yes.
And so, does everyone agree that timing, though, the conviction of that,
I see what you're saying. I don't think that one does, but I think the 2 state jail felonies bump it up to a 2.
they don't do anything? State jails don't do anything to a TDC case. And if I convicted him on an MTRP after this offense date, then he wasn't convicted on the offense date, and so that doesn't make it sequential. Am I right?
I think you are right, Judge, so I do think it goes to the,
I don't disagree that there could potentially be a cumulative request, but I don't think it would enhance his punishment, because I think it has to be a prior felony conviction before the date of this offense. Help me out, am I right? I'm looking at all the lawyers, everybody?
I think
Yeah.
you are, Judge. Yeah.
Okay, so forget everything we just said. The range of punishments between 2 years and up to 10 years in your case. State's offered 4. You can take your 4, you can go to trial. Mr. Wilkerson will remain your attorney. So what do you,
I want to go to trial.
Okay.
And I want to see what is the outcome if I can get my own lawyer.
well, yeah, so you have the right to hire your own lawyer at any time. But because you're in custody, we're going to move forward with your case. I'm clearly going to appoint you someone. You're not just going to sit in jail without a lawyer. We're going to make sure you have representation, and your case is going to move along. So if your family or you has the funds to go hire someone, then by all means, you need to get them hired,
Yes, ma'am.
and they can substitute in, and they need to get ready for trial also.
Yes, ma'am.
Until or if that happens, if it doesn't, we're going forward, case will be on the trial docket, we're going to move forward. We're not going to keep putting it off for that to happen.
Yes, ma'am.
If it happens, great, but as of right now, you're rejecting the 4. I also want to make sure you understand, Mr. Smith, is there any reason to believe that that offer of 4 would change?
No, Judge, and in fact, we had offered to dismiss the case against the co-defendant in this case for his plea in this case to run concurrently with the time he's already served. In fact, it would be for less time, so.
Okay, so I do want to make sure you understand that there's not going to be any new offers. The offer remains what it is, no matter who your lawyer is.
Yes, ma'am.
And that there is the potential for anything you get from a jury to be stacked on top of that 8 years that you already got. You understand that too? Okay, we'll get it set for trial. You can go back with the bailiff. And so I am going to deny the motion to withdraw. All right, so on John Jones, let's just go through rejections, I guess, on all 4, and then
Yes.
we'll set it for trial and figure out whatever to do on that state jail later. All right, sir, you're John Jones?
Yes, ma'am.
Give me just a second, let me get your, everything pulled up here. See, Mr. Jones, in cause number 25 DCCR 0523, you're charged with a first-degree felony offense of murder from April 28th of 2025. Sorry, I'm pulling one. And what that means, sir, is that if you go to trial and you're found guilty in that offense, the range of punishment would be between 5 years and up to 99 years or life in prison. Do you understand the range of punishment?
Yes, ma'am.
And then in cause number 24, DCCR 2431, you're charged with the state jail felony offense of unauthorized use of a vehicle from October 15th of 2024. What that means in that case is that if you go to trial and you're found guilty, the range of punishment is between 6 months and up to 2 years in the state jail prison. Do you understand?
Yes, ma'am.
And then in cause number 25, DCCR 1352, you're charged with a first-degree felony offense of aggravated robbery from September 18th of 2024. What that means in that case is if you go to trial and you're found guilty, the range of punishment is a minimum 5 years up to 99 years or life in prison. Do you understand?
Yes, ma'am.
And then finally, in clause number 25, DCCR 1353, you're charged with the second-degree felony offense of robbery from September 18th of 2024. And in that case, what that means is if you go to trial and you're found guilty, the range of punishment is between 2 years and up to 20 years. Do you understand?
Yes, ma'am.
And then I have here on the tablet in those cases some plea bargain rejections that you've signed with Mr. Wilkerson. They show that the district attorney's office has made an offer if you wanted to enter pleas of guilty for a 35-year term in the murder case to run concurrently with a 35-year term in the aggravated robbery case with a dismissal in the robbery as well as the state jail felony unauthorized use. Is that correct?
Yes, Your Honor.
Do you understand what their offer is?
Yes, ma'am.
And have you gone over it with Mr. Wilkerson?
Yes, ma'am.
And do you want to reject that offer and have all 4 of your cases set for trial?
Yes, ma'am.
All right, is there any reason to expect that those offers would change any evidence that you're waiting on that you guys haven't received or gone over?
No, Your Honor, not at all. In fact, the state will likely be filing a motion to accumulate the sentences to the extent that we can. I think 3 of them would come by one occurrence, and then there's one from a separate occurrence.
You've actually got 3 different dates. So you've got ag robbery and robbery from September of 2024. You've got an unauthorized use from October of 2024, and then the murders from April of 2025.
To the extent we can accumulate all of those, Judge, we will seek to do so.
So I want to make sure you understand, Mr. Jones, that if you are found guilty in more than one of these offenses by a jury, the state can file requests that I stack or run cumulative, which means stack on top of each other any punishment that you receive. Do you understand that as well?
Yes, ma'am.
And that after today, I will not accept this agreement for a 35-year term. If you change your mind later, you can enter a plea open to the court. You can enter a plea to something different, but it's not going to be 35 years. Do you understand?
Yes.
All right, and do you want to have all of your cases set for trial?
Yes, ma'am. I got a question though.
Yes, sir.
Like, it's my offer 35, right? Like that's what the DA's offering, right?
Uh-huh.
My co-defendant admitted to it, but he got a 30-year offer.
Here's the thing. Your offer is what your offer is. He may or may not have had the robberies before he would, listen, I don't know. I know the offer is what the offer is. All right? So either you take the offer or you go to trial and let a jury decide. I'm not involved in negotiations. I'm not going to tell the district attorney's office what to do. That's not my job. But you don't get to, everybody has different issues in their cases that they feel important and why they would make different offers for different co-defendants. All right? So you're not going to have a different offer, and that's what I want to make sure you understand. Even though there was something different for your co-defendant, the district attorney's office has said, this is it, this is your offer. Do you understand?
Yes, ma'am.
Okay, and you want to reject it and go to trial?
Yes, ma'am.
Okay, we'll get it set for trial, and Mr. Wilkerson will begin preparation. You can go back with the bailiff.
Thank you, Your Honor. Be excused.
Thank you, sir.
This is not just a case. This is a fight for justice, where one question from the judge can change a life forever. The silence of the victim, the arguments of the lawyers, and the verdict that decides the truth. Welcome to Court and Courtroom, where every case reveals a new truth, and every truth leaves a lasting impact.